Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court, and I hope you're just having the most wonderful day. We are here with your legal news roundup, all the legal news happening in your world so that you might be better legally informed. We begin this morning with Trump's lawyers may not, in fact, be the best lawyers news, as Trump lawyers appear to have made a very simple, trivial, rookie mistake by never asking for a jury in relation to the business cases currently undergoing in New York in relation to Trump. So, as I'm sure you have read in the news, Trump has been accused of fraud in various business dealings in New York through his various companies, LLCs, and other entities. And we read some of the preliminary stuff that the judge had ruled, because they ruled on some stuff on preliminaries because there were no genuine issues of fact. So they've already basically ruled against Trump in substantive part. Well, normally at this point we would get past the initial motions and we'd go to a jury trial, but they never asked for a jury trial. They never asked. They never asked for a jury trial. So there's no jury because Trump's lawyers never asked for a jury. So the judge, which has already ruled against them in the initial motions and in the partial motion for summary judgment, is now the sole finder of fact. Because there's no jury, because Trump's lawyers never asked for one. That's just super duper wonderful. So that's what's going on in New York. Let's learn a little bit more about this. Former President Donald Trump will not receive a jury trial in relation to the $250 million civil fraud case in New York because of the one simple trick. His lawyers never asked for one. Yeah, that kind of makes that easy. You know, it's like, yeah, you don't want a trial by jury? Okay. You want the judge to be the sole finder of fact as well as the sole finder of law? Okay. I suppose you could have it that way. And now you're having it that way with the judge that's already ruled against you for partial summary judgment. So probably not going to end very well for you. Trump's trial relating to the civil fraud case as it relates to his business dealings in the downtown Manhattan courtroom also had the president make a surprise appearance for all the good it will do him. The case was filed in September 2020 when the New York Attorney General announced that her office had filed the sweeping lawsuit against Trump, his sons, and Donald Jr., and two other executives at the Trump Organization. Although in some senses it would be more correct to say that the lawsuits were brought against the business entities rather than the individuals themselves. I mean, it's not wrong to say it was brought against the individuals, but I think it's more correct to say it was brought against the business entities, because this is all relation to whether the business entities are good, right-keeping business entities, or are bad, law-breaking entities. In which case, if they're bad, law-breaking entities, the business entities don't get to be businesses anymore, otherwise known as the corporate death penalty. You don't get to be a corporation anymore. And also, all the people who were officers of all those companies don't get to be officers of companies anymore in New York, because they were officers of the company that was engaged in, you know, all the malfeasance, and being officers of the company, you know, they're kind of a little bit responsible for that. So, yeah. The case, which has already found that Trump committed years of fraud and already handed down the corporate death penalty for the Trump Organization, is now in a bench trial for remaining parts of the lawsuit. No jury for you. During a bench trial, the judge plays jury. They listen to all the evidence and ultimately decide on all questions of fact. So it's one person's decision. The one person who's already ruled against you in part. How do you think that's going to go? This leaves the fate of the Trump companies in the hands of the judge who's already repeatedly ruled against them and their lawyers, who the lawyers and Trump have already attacked the judge. So, yeah, the Attorney General's office has sought to disgorge his company, which means give us money, issue a $250 million penalty against the defendants and strip them of their ability to do business in New York evermore. While Trump has raged on social media in recent weeks about the decision that there is no jury trial, he only has one person to blame, namely himself, via his lawyers. On July the 31st, the New York Attorney General's office filed the paperwork telling the judge it had completed all its pretrial work and was preparing for trial. On that form, the New York Attorney General's office checked the box saying trial without jury. And as you picture right here, there's just a little box that you check. Do you want trial by jury demanded of all issues, of specific issues? Do you want trial without jury? What kind of trial would you like? The Attorney General, for their part, says we would like a trial without jury. Okay, so they filed that by literally checking a box. Trump's lawyers, however, never filed anything in court arguing otherwise. They, of course, could have. Like the Attorney General doesn't want a jury trial, but of course you might want one. And you're allowed to disagree, but they just didn't ask. Yeah, it's a pretty big issue. One of the attorneys representing Trump in the case say Trump wanted a jury, saying, I know my client did want a jury, and we did want that, but didn't explain why they didn't ask for one. So the client wanted a jury trial. I suppose because this is a civil case, that the lawyers could have disagreed with that assessment and been like, we're not going to ask for a jury trial, screw you. Because unlike a criminal case where you have the right to a trial by jury, you don't necessarily have that right in a civil case. So the lawyers could have been like, no, we disagree. But the lawyers here say, well, my client wanted one and we wanted one, but we just never asked. It's going super duper well over here in New York. It's not, let me just spoil it to the end of the page, guys. It isn't ending well. Let me tell you the inevitable result. All of Trump's companies go bye-bye, big ass fines. Trump never gets to be an officer in any company in New York. So sorry to be the spoiler for the movie, but I know how this movie ends. There's not a lot of ways for it to go. After appearing in the courtroom, Trump, for their part, lambasted the judge and their law clerk, which when the judge is currently sitting hearing your case, not exactly a great move. Rule number one of litigation, don't piss off the judge. The judge was already pissed off at you, by the way, as we've discussed. So, adding fuel to the fire is not going to help. He stood directly outside the courtroom saying the judge was getting away with murder and calling them a Democratic operative. They're a judge, though, and they're the judge in your case. And it's not going to end well, mostly because you never asked for a jury. In remarks at the beginning of the trial, the judge noted for the record that neither side asked for the jury and mentioned frequent quips and pop culture references throughout the court proceedings, saying, quote, I promise to do my best, despite my lame attempts at humor. As I mentioned in the early phase of the case, I take my job very seriously, which I'm sure they do. Judges sometimes aim for the funny, sometimes they're not very good at the funny. Incidentally, it's not really a good idea to aim for the funny in court. If you try for the funny, it almost inevitably goes wrong. The funny tends to be more organic. If you're like, I'm going to pepper this with some jokes, it tends not to go well. So the judge may have tried a couple jokes along the way and, it didn't really work. But, they're like, well, I'm going to do my best. I'm sure you are, Your Honor. We all know how this story ends. Let's wrap this up. Boosh McFadden says he was never going to get a fair trial and all this matters. Fuck you, is all I have to say to that. Even if that's true, you try, you asshole. Of course you do. What do? You just lay down? What is your recommendation? Oh, he's never going to get a fair trial, so he should just lay down on the street and allow himself to be run over? What kind of mentality is that? I really hate this line of argument, by the way. I hate this line of argument when it came to the whole issue of Trump moving for removal to federal court in the whole Georgia thing. Like, oh, Trump was never going to get it. The fix was in. Fuck that. Fuck that. You try anyway. Of course you do. You may lose, but like, you know, you fight. And not for least of reasons, because you can appeal. God damn, it pisses me off. Hebus has said it was forced by rule. Oh my fucking God. I swear to God. It finishes an appeal. There's nothing to appeal over. How is Trump going to appeal this? You can't, it's like, oh, I'm going to take it to appeal. Appeals are for losers. I'm going to take this to appeal. Uh-huh. Yeah, on what basis? Thus, that brings us to the end of the case for the moment about Trump lawyers never bothering to ask for a jury in New York. And so things are not ending well in that domain, as Trump has already gotten the corporate death penalty for the Trump organization and probably going to end that way for all the business entities that are involved in this case, plus fines, plus disgorgement, give us the money, plus a lot of things. And yeah, so the result is somewhat forecast by the process that has been underway. And he never even bothered to ask for a jury to try to, you know, deal with this differently. So all that. And at least for a moment, that brings us to the end of discussion of this story. Appeal means delay, not that much. See, I'm off my game. I'm off my game. I'm really mad about the audio issue from earlier, and it's completely thrown me off. I'm mad. I'm short. I shouldn't have reacted that way to Bush. But Bush said something that got under my skin, and because I'm already tilted, as they say, I didn't react to it well. I'm not even sure the stream should continue at this point. I don't know if I can continue the stream. I am so off my game. I tried to reset and put on a happy face, but I'm just pissed. I saw the video of his judge explaining how he has the power to overrule juries. Yes, it's called a judgment notwithstanding verdict. Also, it doesn't matter because once again, there's no jury. Need an engineer. I need my software to work properly is what I need. That's what I need. Can I show you a business card I've been working on that I've been designing in an effort to try to reset the stream into something vaguely representing something? I've been working on a business card design so that I have something like, you know, hand out to people occasionally, you know, like if I'm at like a meeting or something and trying to introduce myself, you know. I'll show you a design I've been working on. This design is not finalized, but it's what I got so far. All right. So I have this traditional business card, rounded corners design instead of square corners. So a little bit more modern look. And then we got the YouTube play button. And then it says Uncivil Law in 20-point font. So nice big font there. And then I believe it's 8-point font below that. It says legal education and commentary. And then the URL, youtube.com/@uncivillaw. So I thought that looks pretty nice. I'm still adjusting like the proportions and stuff, but I think that looks pretty nice on the black background. You know, really sort of like modern aesthetic mystique. You know, I think that looks nice. And then for the back of the card, we got my picture from my banner on my website. So I reuse that picture of me in the hat with a little scruff on. I kind of like that look. A little bit of mic there and the thing. I kind of like that look there. And then my channel logo in the upper right corner. You know, smaller kind of logo there just for the channel logo. And then Kurt Mueller, ESQ, host of Uncivil Law, and then a QR code, which just goes to my YouTube page. And then I put the banner from the bottom of a YouTube video, like the little banner that, you know, has a little thing to select, you know, play and all that rest, and the bar. I just, you know, took a little screenshot of that basically and put that on the card so it kind of looks like a video. I thought that was cute. So you got that little bit of, you know, the little red there shows like the video is kind of partially playing, and you know, a little bit of lag there for some loaded stuff at the length of the video and all the buttons from YouTube. I thought that looked pretty cool, you know. So it kind of looks like a video. I thought that was nice. So that's sort of the design we got go so far. Yeah, the video control bar I thought was a nice touch to make it and you get that little red accent in there as well, you know, because it's all colorized. So you get a little red accent in there and, you know, all that stuff. And I thought it was yeah, so it looks like a YouTube video. And I thought that was, you know, I thought that was kind of cute. There is no second one, by the way. This is a front and back of the same card. So it's a double-sided card. I suppose which is the front and which is the back is in the eye of the beholder a little bit, because obviously if I hand it to you, which is the front and which is the back, you know, how do you know? But either way, like, it doesn't really matter. But arbitrarily, this is the front of the card, and arbitrarily, this is the back of the card. Thank you, Sandy, for $50. I've been playing also with this like YouTube logo in particular. I've made it bigger, I've made it smaller, trying to get the right size and right proportion of the logo has been a little bit hard because I've been having to kind of do it by eye. I wanted the Uncivil Law 20-point font for the Uncivil Law, making that bigger, and it has sort of guided the overall margins of everything. Of course, like this grouping, like the grouping, and so the image of the YouTube logo with the text as a box. If you imagine a box, it's completely centered, which should be obvious. It's exactly in the center of the entire, like, if you put a box around the grouping, the box is centered so that the entire thing looks. I also like tried it earlier with the YouTube logo in the center. So this entire thing would have been lowered with the YouTube logo in the center, but it looked off to me. So I brought the logo up so that the entire box was centered rather than the YouTube logo being centered. The only other thing I could do, like, is change this QR code to, instead of go to the YouTube channel, to go to like my linked tree, which has all my links on it. But that's like requiring them to do steps. The only other thing I could do too is that when they scan it, it's a subscribe link. So the very act of scanning it causes a pop-up to say, do you want to subscribe to this channel? So right now this doesn't create that prompt that says, do you want to subscribe to the channel? It's just a link to the page. But I could change it so that it gives the prompt. It's like, do you want to subscribe to this channel? But yeah, I thought, and you get it, I'll get it printed on like medium stock. So I won't get it printed on like the thinnest stock. I'll get printed on the, and I don't want ultra thick stock because I don't really like the way that feels. So I don't want the really thin stock because it feels flimsy. And I don't really like the way a really thick business card feels in your hand either. So I'll go with like the medium stock. So I'll pay a little bit more for the slightly thicker stock so that it's a little bit more sturdy. The cutoff at the top of the hat is weird. Yeah, that's just how it looks on the YouTube page. Yeah, I think with it going to the sub thing, I think it's a bit intrusive. I think. So I'm still debating it, but that's one of the things I think. I could also do foil letters and play button and make it shiny. That's true. I could do it in foil, which would be an increased expense, but I could do it with some foil and make the play button. It could make the play button and the logo shiny. So I could do that. I might redesign it in a foil and see how that looks. But that's where we're going. So anyways, so we might try foil and see where that goes. We'll see how much more foil costs. Yeah. Here's how the two halves look together. But they'd have rounded corners. So anyways, pressing on. It's just nice if I'm out and talking to somebody, right? And like, oh, what do you do? It's like, oh, I have a YouTube channel. Here's my business card. It's just nice to have. It comes up sometimes. You know, if I'm out and about meeting people. So you have a business card. I'm not sure if I pushed the button already, but I'll push it again. In gun control news, the state of Connecticut has passed and put into place some of the most sweeping gun control legislation in the nation, partially in response to Sandy Hook, partially in response to it being Connecticut. And they're trying to, you know, do all the things to infringe the Second Amendment, which of course should not come as a surprise to anybody, but that's where we are. So let's learn a little bit more about these new gun control measures in Connecticut. Let's get started with this. Connecticut's most wide-ranging gun control measure since the 2013 law enacted immediately after the Sandy Hook Elementary School shooting takes effect on Sunday, with proponents vowing to pursue even more aggressive legislation, of course, despite challenges happening across the country. So as always, when it comes to gun control, it's never enough. They've gotten a lot, they want more, they will not be happy until the guns are illegal. That is where we're going with all that. So yeah, the law, which was signed by the Democratic governor in June, bans open carry of firearms and prohibits the sale of more than 3 handguns within 30 days to any one person, with some exceptions for instructors and others. We will not take a break, and we cannot stop now, and we will continue to pass life-saving laws until we end gun violence in Connecticut, which of course will never end. So that makes it, you know, a perpetually valuable thing, because of course gun violence will never end. People will be violent. They will be violent with guns. And of course, it will never be enough until the gun violence ends, which of course means it will never be enough, which I suppose is part of the goal. Immediately after it was passed, of course, the law was challenged in court by gun rights supporters. Connecticut's landmark 2013 law, passed in response to the Sandy Hook shooting, is also, of course, being contested in court as well. Of course, since New York versus Bruin, these challenges have become a lot more easy and a lot more different. So even though these challenges have been in place for multiple years, the recent change in Supreme Court precedent makes the challenges a lot more viable than they were in the past. So there's some hope there for supporters of the Second Amendment. Besides Connecticut, other states, of course, are also doing their part to violate the Second Amendment. Colorado, Washington, California, and Maryland are among others that have passed gun laws this year, also, of course, facing challenges in their own states because the U.S. Supreme Court said, you know, the test is the historical test, which incidentally is basically, essentially, exactly how we think about the First Amendment. So it's not rocket science. This is what we do. When we want to understand what the Second Amendment is, we look to history, the same exact way we would for the First Amendment, or for that matter, any constitutional provision. What does this provision mean? Well, it's informed by the history that got us there. So yeah, the California governor, for their part, last week signed nearly 24 gun control measures, including laws banning firearms being carried in most public places, while doubling taxes on gun and ammunition sold in the state. He, of course, acknowledged that this might not survive a legal challenge because it won't. So, excuse me. So when it comes to taxes, the way that you would look at this typically is it a tax specifically on the protected thing, or is it generic tax? Generic taxes are permitted. Specific taxes on protected things are not. So for example, can you have a tax on books? Well, it depends. Is it the same tax that applies to just anything in general? So is it like a general sales tax that just applies to anything that's sold? Then yes, you can. You can have a general sales tax that applies to anything that also happens to include books. But can you have a tax specifically on books? No, because, well, books are a protected First Amendment thing. So while you typically can have specific taxes on specific things, You can't do it when the thing is protected by constitutional articles. So are these taxes on the firearms and guns and ammunition legal? Probably not, because these taxes are specifically targeted to those specific things, making them an unconstitutional restraint. So I would expect those to eventually be struck down. The president of the Connecticut Citizens Defense League was quoted as saying, "It's not common in Connecticut to go to the grocery store and see someone with an exposed firearm." I bet it's not. Does it happen on rare occasions? Sure, but it's not a problem in our state. Saying already there are laws on the books that help address people illegally carrying a weapon in public or otherwise abusing open carry laws. So they're trying to solve a problem that doesn't really exist because, they want to be seen to be doing something. So that's where we're at. The new law also increases bail and toughens prohibitions. The new law also increases bail and toughens probation and parole for what officials call a narrow group of people with repeated serious gun offenses. So as states are trying to get rid of bail conditions and get rid of cash bail and let everyone out of jail, the one exception they're willing to make is for the gun people. How fun. They'd also like to stiffen penalties for what they call large capacity magazines and expand safe storage rule to include more settings and add some domestic violence crimes to the list of disqualifications for having a gun. Republican leaders, for their part, who represent the minority party in Connecticut, accused Democrats of bragging about how safe Connecticut is because of gun laws. At the same time, there have been carjackings, serious property crimes, and other acts of violence. The minority leader, a Republican from North Branford, says Connecticut is one of the safest states and that these laws are a slap in the face to residents. Enough with news conferences. Democrats should step away from the lectern and tap into what's happening in their districts, he said in a statement. God, I have a headache. I'm really sorry, guys. I'm sorry. I'm sorry. I don't know if it's due to depression. It probably is. It probably is due to depression, but I think on attendance, I think on a whole, I probably wear my emotions more on my sleeve than a lot of my compatriots. And I think it's more obvious than a lot of my compatriots when I'm having an off day. At least my own perception of that is. I think I reveal it more. I think it's more obvious when I'm having an off day. And I started with an off day. I started an off day. It's one of those days where things are just, going wrong. Started late. Had problems with the audio. Was disappointed in, how the stream was doing. Yelled at Boosh. It's going great. It's going great. Just going super duper wonderful, guys. Also, just incidentally, and it just I did my last improv class in my current school last night. And I found this improv school to not be particularly good. I was not particularly impressed with their education. I didn't really want to go, but I decided to go anyway to kind of see the class through. And it's like, will you be signing up for the next level? Nope. So that's disappointing. The state Senate President pro temp, a Democrat from New Haven, for their part, called the legislation a very significant initiative, but stressed that the battle is not over. So you better believe they're going to continue coming for your guns. According to the President pro temp, Connecticut is vulnerable to states with looser gun laws, therefore wants to pursue further limits on monthly gun purchases and require micro-labeling or ammunition microstamping, which incidentally is technology that has never worked. It is technology that looks good on paper, but it doesn't really work. It has never once solved a crime anywhere, to the best of my knowledge. This is the idea that you can mark the ammunition with unique things from the gun, and you send a test casing, right? You send a test casing from the firearm to the state registration bureau, and that gun has unique characteristics that can be identified by a fingerprint, but it simply isn't good enough. Not for the least of reasons. Incidentally, the parts wear down mechanically, and so as the gun gets used, the signature becomes more and more distorted, and also they're not unique enough in the first place for the purposes of this matching. So yeah. Ellen Parker gifted 20 gift memberships. Thank you, Ellen. I appreciate your support. Lamont, who proposed a newly enacted law, said he's interested in working with fellow governors in the Northeast to draft similar laws, given how technology is changing so fast and Connecticut can only do so much within their own borders. And my Zyrtec does not appear to be fully working today either. This day sucks. Thus, that brings us to the end of the story about Connecticut's new gun laws going in place, trying to put more restrictions in place, and also somewhat thumbing their nose at the Supreme Court. Not that Connecticut is in any sense alone. Many states have thumbed their nose at the Supreme Court, which, is no surprise. They've been thumbing their nose at the Supreme Court ever since McDonald and Heller, and Bruin is nothing new. So the Supreme Court will have to continue teaching these people that, the Second Amendment is a thing. I wish the Supreme Court would take more Second Amendment cases. They have won this term, but they're going to bounce it on other grounds, I'm pretty sure. So they're not going to decide it on Second Amendment rationale. So I wish they would take a couple more cases. I mean, every year they hear a couple First Amendment cases. Why can't they take a couple Second Amendment cases every year? I don't know, but they don't. So for the moment, these states can continue to do this thing as the fight continues. And that for the moment gets us to the end of this story. Thank you, D. Canuck, for your super chat. Or your gift memberships, rather. Change the background and push the button. And push the button. Yay. Well, guys, I think this is going to be the end of the stream. I have plenty more stories, but I don't know that I can continue. Maybe we'll try doing another stream later when I'm in better spirits. But I don't think I can continue for now, and I'm sorry. I've let you down. I guess I'll finish with Florida man early and call it a day. I'll finish on Florida man because Florida man usually brings us joy. So we'll bring Florida man to us and hope it brings us some joy. Okay. In Florida woman story, Florida woman who has a history of the streaking at the sports games and likes doing it says a new Florida law which enhances the penalties for streaking at sporting events and other public places says they're going to continue the streaking. The new law will in no way dissuade them. They like the streaking. They want everyone to see their body in all of its glory. She likes the exhibitionism. She's going to continue doing it no matter what. So that's what's going on with that. Let's learn a little bit more about Florida woman's pledge. Starting this week, Florida has a new law stiffening penalties for attention grabbers who sprint across sports fields. But one well-known streaker says this law won't work. I think it's just a scare tactic, says Instagram model and influencer Kelly K, who jumped from the stands to run across Hard Rock Stadium field in Miami Gardens during the Super Bowl in 2020, referring to the new law increasing fines on offenders and allowing authorities to seize assets, among other penalties. So Kelly K, who fashions herself an Instagram model and would like you to know about her Instagram modeling, sees these streakings as just business development opportunities. So she's like, the new law will in no way dissuade me. People need to know why they want to subscribe to my Instagram. How fun. To tell people not only are you going to get in trouble for this and go to jail, they'll get a charge. We're going to take your money, said Kay of Knoxville, Tennessee. But if it were me and the law were in effect when I ran onto the field, I would do it because of the long-term effects. She sees it as a business development opportunity, and it might come with some penalties and some costs, but she has done her own business calculation and she thinks it's worth the business enterprise development. So she plans to continue the streaking. How fun. Kay, who was then 27, was tackled by a security guard quickly near the end zone. She was arrested and hit with trespassing that was dropped. Since then, she has soared to 1 million Instagram followers. Here is pictured Kelly K, 31 of Knoxville, Tennessee. So she's actually a pretty good looking woman on top of everything else. And she would like you to know about her Instagram. So this photo, by the way, is her jail booking photo. So if she looks this good in jail booking photos, you know, she has some assets she'd like you to see. Yeah. The anti-streaking measure in Florida, called interference with sporting entertainment events, received a nearly unanimous support in the legislature. The governor, of course, signed it into law. The bill was offered primarily to stop streaking, in which people run across the field nude or partially nude. Kay was walked off the field by security while exposing pink thong underwear under a black cover-up. This is fun. The person who supported the bill saying, quote, "I have 4 daughters and a son. You save money and take them out to a baseball game or a football game, and the last thing you want to see is someone running around indecently for corrupt financial gain." The lawmaker added the new law might not prevent the influencers from seeking fame, but hopes it will give them pause, saying, quote, "You're going to have the social media influencer, but you know it could really hurt their career. There's a lot of things that could happen. They might think twice about it." The law applies to all who storm onto fields or arena floors during sporting events, whether fully clothed or not, and includes fans rushing the stage during concerts and artistic events. The bill sponsor says, in many cases, those individuals running across the field are doing so at the behest of others, such as website owners who seek publicity for themselves and are paid to do so. So in some cases, they are merely paid actors. Any individual soliciting a person to carry this out in exchange for something of value can be charged with a third-degree felony, which is punishable by up to 5 years in prison and a $5,000 fine. So if you're thinking about hiring a streaker, you might want to think again. The new law also authorizes to seize the assets of any person who rushes or streaks at an entertainment venue and who is paid. So we'll get any money that you were offered for this deal. So if you were paid, we'll get the money that you were paid. They can also face charges of first-degree misdemeanor, which is punishable by up to a year in jail or a fine of $2,500. So they may have to do some jail time. Individuals who rush and streak the fields or other entertainment venues, even without being paid, will still be charged with a misdemeanor. So if you do it for money, it's a felony. If you do it without getting paid, still a misdemeanor. Previously, rushing and streaking was punishable by jail time, but the maximum fine was $1,000. So, you know, they didn't really increase it for the people who are doing it without pay. I think there might be another photo of her too. I thought I saw the thing. Yeah. There she is. There she is. Thus, that brings us to the end of the story of Florida's new anti-striking law, and also the story of Kelly Green, pictured here, who enjoys the streaking and plans to continue striking no matter what they do. They're threatening her with jail time, but they're like, you can't really do anything for me. I'm just using this as business development. So she plans to continue the streaking. So you can look forward to seeing that, I guess, at your respective games. At least for the moment, that brings us to the end of discussion of this story. All right, guys, I am sorry that I'm a little bit off my Uncivil game today, and I'm sorry, Boosh, for the way I responded to you. I should not have responded that way with that language. That was uncalled for under the circumstances. I'm just very, very frustrated by the argument because I think it's kind of a nonsense argument. Like, it's just a nonsense argument, at least to me. It's like, the fix is in, so Donald Trump shouldn't even try. Is basically like, this is one of the things I saw with like response to the whole thing with this is one of the things I saw with response to the whole thing about Trump not seeking removal. It's like, well, of course he was going to lose. Of course he's going to lose. There's no fair jury. There's no fair judge. The fix is in. He's doomed. And I'm like, even if all those things are true, which I'm not sure it is, incidentally, but even if they are true, it's all the more reason, not less reason, to show why you're right under the law. So the fact that they are doing their witch hunt is more apparent. You know, the fact that they are bending and twisting and conjuling the law to find you guilty no matter what you do is more apparent if you resist. Right? If you just go along with it, the fact that they're doing that is not obvious. So I don't understand this argument. I really don't. I really don't understand the idea that Donald Trump is doomed. The fix is in. Of course he's going to be found guilty. You know, there's no reasonable jury that could be found, no reasonable judge that could be found. They're going to do whatever they can to get him. But therefore, he shouldn't raise the legal arguments. Therefore, he shouldn't fight back legally. Therefore, he shouldn't expose them as doing exactly that, because their decision to persist despite the law will become even more obvious. It just doesn't strike me as a reasonable conclusion. It strikes me as a very, very odd conclusion. And I had a lot of people that were like that. You know, of course Trump didn't fight. He realized that it was pointless. I'm like, first of all, I don't agree that it's pointless. He might have lost anyway, but I certainly don't agree it's pointless. There are a lot of people out there. There's a fair amount of legal scholars out there who think that Donald Trump would not have been successful. in his bid. They might be right. They might be right. Their analysis could be correct. I think there are some countervailing arguments. So I don't think that they're necessarily like the only way to look at it. But the way that a lot of lawyers have looked at this, or a lot of commentaries are like, yeah, Trump can't get this removed. That's a reasonable conclusion. It's a reasonable conclusion. But the other conclusion is reasonable. You don't just give up. You don't just give up. You don't be like, well, geez, the other side has a reasonable argument, therefore we're going to lay down. It's like, if you have a reasonable argument, you fight. You fight. And if they persist despite reason, then it becomes more apparent that they're fighting despite reason. So the idea that Donald Trump wouldn't ask for a jury in his New York case, the idea that he wouldn't seek removal in the Georgia case because he's doomed, strikes me as an absurd argument. I don't understand it. And so I overreacted against Bush because it's something I've heard. And also I'm a little bit pissed because this was something interesting. Like I probably shouldn't read the comments of videos, but I did an attorney's react recently. And this guy, not for the first time, has basically been insulting me because I'm giving him the right legal answers. And he's insulting me because I'm giving him the right legal answers. And it's like, what the fuck do you want from me? So I did an attorney's react recently. And also, like, can I just read these? Yeah, I can do whatever the hell I want. It's my channel. We're doing this now. I want to react to some of these comments on this video because some of these comments were driving me a little bit crazy. Because, like, I don't know what to do. I don't know what to do with these people. All right, so we're discussing this for a while now. All right, so this is all in regard to this video. Real lawyer, that's me, reacts to confused DoorDash driver getting tased. All right, for those of you who haven't seen the video, let me give you the too long didn't watch. DoorDash driver is driving down the road. Cop pulls him over for speeding. Says he's going 16 miles over the limit, got him on radar. Cop asks for driver's license, registration, proof of insurance. It's like the driver says, can I see the radar gun? No, if you want to fight it in court, you fight it in court. You're not entitled to a registered education. Okay, I'm not giving you my license. Can I get a supervisor? No. Okay, I'm just asking questions, right? Get out of the car. The cop then tells him to get out of the car like 16 times and then tases his ass. And I'm like, yep, looks okay to me, right? And I'm like, yeah, the cop can get you out of the car because the Supreme Court has twice said that they can order you out of the car in the ordinary routine traffic stop. They don't need a special reason. Any reason will be fine, right? Any reason will be fine. They can order you out. They can order the passenger out. It's just something they can do. And so like then he refuses to get out. So now he's resisting. Now he's disobeying a lawful order. And so now that's an arrestable offense. And now we can force escalate it, and we force escalate. We initially tried words. We're now trying hands, right? We're trying stronger hands. Okay. Hold on 1 second, please. I have to take care of something real fast. Hold on, please. Talk amongst yourselves real fast. Check 1, 2. Dun, 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 dun. Oh my God. $11.08. Yeah, $9.37. Shit. Fucking bullshit. great. I'm back. In response to the question about the driverless car, who would be responsible? Under current law, there's no driverless car that absolves the driver responsibility. So under current law, the driver has responsibility. In the event of a true AI car, then if the AI car makes a mistake, product liability. It'd be product liability, at least under current law, how we would view it. Product defect, right? The car was defective because, you know, it did bad things. So the company would be liable under current law, under standard product defect law. But of course, as you would imagine, you know, when this technology eventually comes to light, one would imagine we're going to write specific laws for it. But under current law, that's how you'd view it. So hopefully that was helpful. In any event, thank you for saying my interview was good. That makes me feel better. I appreciate that. So there were some comments that made me like a little bit crazy. So so he got tased and I'm like, yeah, this all looks good and stuff like that. I like this comment by Leader Larry. Please stop calling them morons for not being educated. We're not taught a ton of things we need to survive in the world, and there's ample misinformation out there. I get why the driver thought what they did. They literally didn't know better. I'm not defending the illegal response, but if we're criticizing someone for failing, it's education and public safety that failed this kid long before the stop. Look, if you like disobey an order from a cop, like, you know, yeah, I'm gonna stick with moron. Lawful does not equal righteous. I think we handle things very strangely in this country, but just become numb to it. Lawful does not equal righteous. Well, it does within some senses of the word. Let's see. But that's not. Yeah, so like for example, like dictionary.com, righteous, adjective, characterized by uprightness or morality, a righteous observation of the law. Morally right or justifiable, righteous indignation. So like, yeah, the fact that it's an observation law makes it righteous. I mean, yeah, in some senses of the word righteous, but that's okay. Someone said this guy is just misinformed in his rights and doesn't know that you don't battle your rights at a traffic stop. I think you're being way too harsh on him and I enjoy watching your videos. I don't know what the fuck that means. This is the law. It's like, this is the law. I'm being too harsh on him. Like, no, he's wrong. It's like, it's wrong. Was it lawful for the officer to draw and fire his taser without warning? Yep. Sure. Usually when officers say taser, 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 it's because there are other officers nearby and they're warning the other officers nearby that they're about to deploy a taser for their safety. But yeah, does he have to warn that he's going to use a taser? No. It's standard for force escalation. He doesn't have to warn that he's about to use a new step in the force escalation chart. He just has to be right. Yeah, prompted me. All right. Yeah. I don't know if it's required, but it seems like the officer should be required to give the driver at least one more opportunity. I mean, he did literally say, by the way, I'm going to tase you. The officer did actually warn him. It's like, if you don't do what I want, I'm going to tase you. Not that he had to, but the officer did in fact warn him orally. I think more than once, incidentally, but I know he did it at least once. So like saying something like, if you don't get out, I'll tase you. The officer said almost exactly that in exactly those words. I don't know if that's the reply, but like, yeah, he did say he was going to fire a tase if he didn't get out. Yeah, the officer said almost exactly that in exactly those words. So, not that he had to, but he did. The driver's an idiot, but I find it interesting how the second he said he was turning on the recordings, the cop escalated further. It didn't feel causal to me. Like he said, I'm turning on the recording, but it didn't feel causal to me. It felt like the next thing that was going to happen. And First Amendment retaliation, not happening. Not happening. Like the officer had probable cause. So yeah, First Amendment retaliation, get wrecked. You know, get wrecked. That's, yeah, no. "108 kid student said, even if you could prove he's speeding, it doesn't matter. Geez, dude, are you done licking these boots? It doesn't matter anymore. It is no longer his biggest problem, right? I pointed this out in the video. Yeah, the fact that you were speeding is no longer the biggest problem. The biggest problem now is that, you know, you refused the lawful order. The biggest problem now is that you were resisting the arrest, which they had the right to do because they were arresting you for refusal to obey the lawful order. So even if you could prove he was speeding, it doesn't matter. It doesn't matter very much anymore. It doesn't matter very much anymore. Like if you could prove he wasn't speeding, in fact, it doesn't matter very much anymore because the officer had reasonably articulable suspicion to pull him over. It's like, yeah, I clocked you going 14. So as long as the officer's telling the truth, and we have no reason to believe he's not, even if you could prove somehow the officer was wrong and he wasn't speeding, in fact, it no longer matters. It matters as to the speeding ticket, but that doesn't really matter very much. So am I done licking the boots? I suppose not, because I'm giving the right legal conclusions, right? It's like if you could prove, unless you can prove the officer was lying about clocking him, which there's no reason to believe that, incidentally. But unless you could somehow prove that, no, it no longer matters. It doesn't matter anymore. The officer had the you know, if you could prove the radar gun was defective, if you could prove he used it the wrong way, if you could prove, you know, as long as the officer didn't have actual malice, like if the officer just made a mistake or, you know, the gun wasn't working or whatever, it's like, as long as the officer wasn't lying, even if the officer violated protocol, you know, just made a mistake in the usage of it, it wouldn't be enough. So am I done licking the boots? I guess not. I guess I'm not done licking the boots because it doesn't really matter very much anymore. It is no longer the most operative problem. We have moved into a different problem. You know what I'm saying? Some guy says, your commentary left a sour taste in my mouth, not gonna lie. Try to relate, this is a misunderstanding. They have got a misunderstanding all day long, but if you don't know something, you get a criminal record. Dude, just like, all he had to do was hand over his license, registration, and proof of insurance. It's a standard traffic stop. If you don't know how to respond to a standard traffic stop, I don't know what to tell you. You know, it's like, but apparently my commentary left things. So I don't understand these commentaries. I don't get this. Mims ruled that the driver had to exit the car for officer safety. Wilson ruled that passengers have to exit the vehicle for safety, but no one has yet challenged the right of officers to order you to pull from the vehicle. And then I simply cite the relevant law. Like he says, oh, it's for safety. Well, I'm like, well, let's go and see what the Supreme Court said. We're asked to weigh the intrusion in the driver's personal liberty occasioned not by the initial stop of the vehicle, which was admittedly justified, but by the order to get the car. We think that this additional intrusion can only be described as de minimis. The driver is being asked to expose to view very little more than the person's already exposed. The police already have a lawfully decided the driver should be detained. The only question is whether he shall spend that period sitting in the driver's seat of the car or alongside it. Not only is the insistence of the police on the latter choice not a serious intrusion upon the sanctity of the person, but it hardly rises to the level of petty indignity. So it's not just for safety, it's just kind of cuz. And then Meg Flop Wilson said, if it's so de minimis, why is the officer using it as a punitive threat? He's not using it as a punitive threat. At least in the moment, he's not. He's saying, get out of the car. Your refusal to do so is now disobeying the lawful order. So he wasn't using it as a punitive threat. It's just like, get out. Also because you haven't complied thus far with me. So yeah, I don't see that as all. Was the officer correct? Yes. Did the officer purposely escalate the situation, do absolutely nothing to de-escalate? Also, yes. I don't see that. The officer was just following the routine steps. The officer was going through steps. I don't get this sometimes. I don't understand this. I don't get it. It's like, some people think like the officer has a duty to de-escalate. Not necessarily. No. They can escalate this. They can de-escalate it. They can escalate it. Kind of plays how they want to play it. But the officer wanted to play it by escalating. It's like, oh, he didn't do anything to de-escalate. Show me a law that says he does. He does have a right to ask for a supervisor. They just don't have a right to grant that. Then it isn't a right. A request. Rights imply duty. No duty, no right. You have a right to request a supervisor. No, you really don't. If you had a right, it implies a duty. My right is your duty. So, yeah. Does Mims and Wilson not violate Bruin? No. Not even a little bit. Not even a little bit. Please address the use of tasers for passive resistance. He showed no threat. Can they use it to force compliance? Yep. My understanding is less lethal was introduced to avoid lethal force. If he had no taser, could the cop shoot him? No. But he can use less lethal. He's going through the force escalation. So I don't see any problem with tasers, it seems really. Kurt is really harsh and nihilistic in his analysis. Layers of law can justify atrocious behavior of all sorts. What a reasonable jury think. What the fuck are you talking about? I'm here to provide a legal analysis. What the hell does that mean? I'm harsh and nihilistic? I'm just giving a legal analysis. This guy's clearly in the wrong. The cop is clearly in the right. There's no ambiguity to this. This guy's behaving like an idiot. There's no ambiguity in this. This is dumb. These are all questions of law. There's nothing for a jury to solve. There's no questions of fact here. The tape speaks for itself. There's no questions of fact. So it's like, none that are operative anyway, right? There's nothing for a jury to do. While you're technically correct, the officer has zero de-escalation skills. I don't know whether or not the officer had zero de-escalation skills or decided not to use them that day. But either way, it's lawful. Right? It's lawful. Is it lawful to de-escalate? Sure. Is it lawful to escalate? Sure. And strictly speaking, I'm not sure really speaking that the officer was escalating. The driver was more escalating. He was the one that was providing the impetus for the officer's response. So the driver was more escalating than the officer, but maybe that's a little bit in the eye of the beholder. Doesn't MIMS require there to be a reasonable basis for safety? Nope. You can't just order people out of the car any more than you can Terry stop someone on the street. You really, really can. So you can claim there's no special reason would be false. I read you the case law. I read you what it said. I read you the paragraph. I quoted it to you. It called it de minimis. It said it wasn't even an indignity. I mean, so the basis of MIMS was safety, but the rationale wasn't limited to safety. I read you the case law. At least how I read it. All right, I read you the right paragraph. Like demanding Granny get out of the car for no particular reason when it failed. No, not the way I read MIMS. Not the way I read Wilson, it wouldn't. I read you the paragraph, right? De minimis, not even indignity. The only question is whether or not the guy is going to spend the time in the car or outside the car. It's not an intrusion. It's not even an indignity. You can order Granny out of the car because you feel like it. That's the way I read Mims. That's the way I read Wilson. Yeah. Accordingly, we conclude once a motor vehicle has been lawfully detained for a traffic violation, police officers may order the driver to get out of the vehicle without violating the Fourth Amendment proscription of unreasonable seizure. So, like, yeah. So it's yeah, it doesn't, yeah. Oh, and then also in this video, I did this thing like, I bet you $20 there's no case that stands for this, because I was tired of people saying it. People keep saying, you know, there's a right to demand a supervisor. There's a right to demand supervisor. I'm like, I got $20 that says there's not. Show me any statute anywhere. Show me any case that says you have a right to demand a supervisor and a supervisor must be provided. Show me that case. Show me that decision. I'm pretty sure it doesn't exist. Like, I got $20 that says there's no case, no statute anywhere in the US that says you have a right to demand a supervisor and one must be provided. That, because it doesn't make any sense. It doesn't make any sense. No, there's no statute, there's no case that says that. It's mind-numbing stupidly. It's mind-numbing stupidity. Low and Slow said the officer just followed the standard steps. Well, that makes everything all right. Good grief. Yes. It really does make everything all right. That's the law. It does. That's the law. The officer just followed the standard steps. That makes everything all right. Yes. Correct. What do you want from me exactly? What do you want from me? It's like, I'm a legal analysis. I'm here to tell you the law. Yes, that's correct. Next question, right? I don't know. Uncivil needs to do some more reading. He's wrong on so many points. Which ones? What reading? I'm wrong on so many points. Which points? What reading? You have a right to demand it. No, you don't. You can. If you had a right to demand, that would require them to comply. That's in the nature of a demand. Demands must be fulfilled. That's in the nature of a demand. I mean, I don't think I'm being unduly semantic, right? If I have a right to demand something, you must comply with me. That's in the nature of a demand. You must fulfill my demand. As opposed to a request, right? I have a right to request things. I have a right to demand things. And if you don't give me what I demand, you're in the wrong. And you can be held legally accountable. Give me my car back. Hey, I loaned you my lawnmower. Give me my lawnmower back. You're on my lawn. Get off my lawn. Right? Demands. The word demand in a legal sense requires fulfillment. Like it's a demand. You must comply. So if you have a right to demand, that means that the other person must fulfill the demand. That's in the nature of the demand. It's like, do people not understand words? It's like, it's like, you have a right, the demand implies obligation, right? Demand requires fulfillment. Demand is because I have a right to demand. So it's okay. Kurt needs to work on his soft skills. I can't watch these videos when he's the reviewer. I just respond to different attorneys for different tastes because I don't know what to do to respond to that. The problem with bad information is you dress it up with good case law. What the fuck does that even mean? The problem with bad information is I dress it up with good case law. What the fuck does that even mean? I mean, the facts are readily apparent from the video. I'm like, here's the case law that speaks to this issue. What does this mean? The problem with bad information is I dress up with good case law. What does that mean? I dress it up with good case law. I'm like, okay, here's a fact. Here's a case that speaks to that fact. Here's the conclusion that derives. It's like, what do you think lawyers do? I'm so confused. I made it 7 minutes and all I hear is it's a lawful stop. So what? Just because the cop did everything lawful, it made it right? Yeah. Correct. Yes. Was the cop on some sort of time limit? He couldn't take in a beat and try to get things this far? Good grief, there's a dozen things the cop could have done before going his hands on and tased. Maybe he could have, but he didn't have to. That's the thing, right? He didn't have to. Were there other steps the officer could have taken? Yes, sure. There are often a multitude of legal options in many scenarios, right? The question is whether the option you picked was lawful, not whether or not there were other lawful options, right? So there's a lot of lawful things one could do in any given moment. There are a lot of choices this officer could have made. The question I'm trying to analyze is is the officer's choice correct? Yes, yeah. Good grief, there's dozens of things the officer could have let its hands on before getting hands and tased. I don't even know what to do with that stuff. I think you answered yourself. The so is what literally is lawful. The attorney is right. If you break the law and decide not to follow lawful order, I don't know what to expect. And the officer did a lot of things. The officer could have acted more physically faster. He only needed to warn the guy once, or ask the guy once. So the fact that he warned him 17 times was like, yeah. And then someone says, in response to all this, someone said, was Uvalde lawful? Was that right? What the fuck is that? How's that what does that mean? Was Uvalde lawful? Was it right? What the hell? It's like, what kind of question is that? My personal favorite here is Ken Van Gelder says, Uncivil needs to be removed from ever posting on this channel. And someone asked why. The channel isn't called Lawyer Agrees with Your Worldview. Hate the fact that the way the law works right now, but it is, and Uncivil's right. I don't agree with him that this should be the way it is, and telling people still has value. The guy would have been better off if been informed in fact about the things work. And the guy says, if lawyers never even consider the morality of court rulings, we get stuck in periods where precedent is never challenged. You wind up with rulings like owners owning slaves being legals. What the fuck? Murdering the unborn being legal and violating the Fourth Amendment being legal. It's critical responsibility of every lawyer on this channel not only know what the precedent is, but also have the guts to say it's wrong and immoral whenever applicable, like here. And then he says, every video on his channel highlights his incompetence as a lawyer. He doesn't even understand basic civil rights enough to defend them in the face of unconstitutional precedent. To which I simply respond, lol, you want me to explain the law against the Supreme Court precedents? And it's like, you know, what am I supposed to do with this? What am I supposed to do with this? Also, I don't typically do morality. I typically do law. Like, this is the way the law is. And I disagree with the law typically for legal reasons, not moral reasons. Like, so for example, my problem with a case like Wickard is rooted in law, not morality. I think the Supreme Court got it wrong legally. I explained why they got it wrong legally. My problems with Chevron is I think they got it wrong legally. I explained why they got it wrong legally, right? So my disputes with courts are typically and almost exclusively rooted in law. I don't typically make moral arguments because laws and morals are not the same thing. I make legal arguments. When I said Roe was messed up, it was based on law. I didn't make moral arguments even in Roe. I make legal arguments. I'm like, yeah, this isn't legally right. The court doesn't make sense legally. So like this idea that I should I don't know what he's asking me to do here. This idea that I should never be allowed on the channel because I don't look at things in a moral lens, and apparently am not disagreeing with the Supreme Court because of morality. I'm like, I don't know what to do with this. You know, I don't know what to do with this. It's so odd to me, right? I disagree with cases because of the law. And incidentally, I disagree with Dred Scott because of the law. I thought the dissent in Dred Scott had it right. It's a legal determination. And it's like, you know, it's yeah. I don't know what to do with this. I don't know what to do with this. And I'm pretty sure this is the exact same guy who previously said, like, cops don't have the right to demand you get outside the road, get outside the car. And I think this is the same guy. And so I'm like, okay, when it comes up again, I'm just going to cite the case that says they can. I'm like, here's two cases that says they can. The Supreme Court said in Mims, they said in Wilson that yes, you can force the driver out of the car. Yes, you can force the passenger out of the car in the ordinary normal course of a roadside stop, which means you don't need any special reason. You can just do it because you feel like it that day. Because, you know, and the only countervailing consideration now, because of more recent case law, is whether or not that request unduly extends the time of the stop. But that case hasn't come up yet, or at least it hasn't been litigated yet, or it probably has been litigated somewhere, but it hasn't come up through the courts of appeal yet. Right. And incidentally, by the way, the correct decision from the Court of Appeals would be to uphold the precedents. It would be up to the Supreme Court to clarify. So only the Supreme Court could clarify it. So as the Court of Appeals, I'd pretty much have no choice but to say, well, like, was it Rodriguez who said, you know, you can't extend the time of the stop? But I would say, well, the precedent says under Mims and Wilson, you could ask him out in the ordinary course. And so that is not extension of the time of the stop in and of itself without more. And so I would, as a Court of Appeals, rule that way. If I were on the Supreme Court, I'd have to think about it differently. But I'm probably not going to be on the Supreme Court. So, yeah. So I'm not sure what he wants me to do here. This is very, very odd to me. And then this guy says, you're just fine with actions like that. For your information, most people don't understand the law like you and the cop. Well, ignorance of the law is no excuse. So, you know, the man did not pose a change or think this could be resolved. But of course, the professional had to go 100%. You think it's funny. I'm like, yeah, it's legal. Also, it's funny. F around to find out. Yeah. So, all those things. All those things. Look, it's really not very complicated, guys, when it comes to roadside stops, at least on the law. It's not super complicated. And you can be both observant of your rights and be polite, by the way. And it would be my recommendation to do both. So here's what you do. If you're pulled over and the cop asks for license, registration, proof of insurance, you give him license, registration, and proof of insurance. None of that's testimonial, incidentally. You don't have a Fifth Amendment right to not give it. And it isn't incriminating anyway. And if you want to, like, not answer the officer's questions, I totally understand. Like, do you know how fast you were going? You could respond with, I don't want to talk about my day, sir. Or, sir, I don't want to talk about my day. Or, sir, I don't answer questions. You could say that. You know, be polite. Sir, I don't answer questions. Sir, I don't want to talk about my day. Sir, I'd prefer to invoke my right to remain silent. These kinds of phrases would be fine. Or ma'am, as the case may be. A sir and a ma'am go a long way. You know, being nice. Show a little bit of respect. They are officers of the law. So, you know, show a little bit of respect. They're in a position that they've been granted some legal authority, and you know that you salute the rank, not the man, as they say. So, like, yeah, a sir or ma'am goes a long way. Can I search the car? Sir, I don't consent to searches. Ma'am, I don't consent to searches. You know, that would be fine. You know, a little politeness goes a long way. Yeah. What if they say, how dare you assume my gender? You could say officer if you prefer. But sir and ma'am are probably the best choices. If they correct you, then correct it. You know, it's like, oh, I'm sorry, ma'am. Sorry, officer. They say, like, I'm not an officer, I'm a sheriff. They say, sorry, sheriff. Officer's fine if you want something more neutral. You can be apologetic. You can be, I don't know about apologetic, but you can definitely be polite. You can definitely be polite and maintain your rights. There's no reason to be antagonistic. For every possible reason. For your own sanity, right? If you're a jackass, the fact that you're a jackass will be used against you in court. If you're polite, it will probably help in court. It can't hurt, right? It can't hurt. If your attorney asks the question, was he polite? And like, yeah, he was polite. He said, sir and ma'am. He is polite. If as opposed to like, you know, he was flipping me off and using profanity and all the rest of it. Politeness will help you. You know, if you show respect to the officers, it will probably be towards your benefit in court. I think saying I don't answer questions sounds a little rude. You can rephrase it if you don't like that phrasing. You know, you could say I don't want to talk about my day, or sir, I prefer to remain silent, or sir, I prefer not to answer that question, or, you know, the phrasing, you can work on the phrasing a little. Right? You get the gist of it, you know, but you don't have to be antagonistic. So it costs nothing to be polite, yeah. Just remain silent. I would not recommend just remaining silent. The Supreme Court has said in order to invoke your right to remain silent, you actually have to invoke it. So for both practical and legal reasons, I would not recommend merely remaining silent. I would recommend simply responding with some version of, I prefer to remain silent, sir. Sir, I don't answer questions. Sir, I prefer not to answer questions. Sir, I don't want to talk about my day. Sir, I'd prefer to be on my way. Sir, I don't want to talk about that. Sir, I wish to remain silent. Some version of that would be fine. So for both legal reasons and practical reasons, I would not recommend remaining silent. I'd recommend verbalizing the desire to remain silent. And also, of course, you probably have to give your name and stuff, especially if you're pulling over, especially if you're driving. You know, you're driving, you have to give the guy your driver's license, your license and registration. I mean, come on, you know. Yeah. I think you should just certainly give your name. It's just one of those things that, like, I'll disagree with a little bit with the, you know, the hardcore auditor crowd. It's like, if a cop asks for my name, I'll give him my name. I'd give anybody my name. So me not giving the cop my name, it's like, you know, what's the point? It's not exactly a secret. You know? The cop wants to know my name, my address, my date of birth, fine. You know, there's no real reason to say no. I don't have any warrants out for me, so there's that. You know, if he wants to see my license, I'll show my license. You know, what do I care? Why such complicated answers when a simple I don't know suffice? But if you do know, technically it's obstruction. Because you're lying. So I don't know only works if you don't know, which some of the time you would know. So if an officer asks, do you know why I pull you over? The correct answer would be, I don't know. You don't know why the officer pulled you over. you might be able to reasonably speculate, but you don't, strictly speaking, know. So if an officer asks the question, do you know why I pull you over? The correct answer would technically be, I don't know. But if an officer asks you a question like, where are you coming from? And where you're coming from is a bar, then I don't know would be a lie, which technically is obstruction. You know, mere refusal to participate is not obstruction. Misleading is. Right? I don't have to help the officer, but I can't lie, because now I'm hindering them. That's the difference between not helping and hindering. Right? Me hindering him is me misleading him, me deceiving him, me preventing him. My not participation is not, it's not obstruction. So the reason you want an answer like, well, first of all, you want the answer like, just as a matter of habit. So you don't want to get into the situation of trying to decide on the side of the road which questions to answer and which not, because you're going to fuck it up. You will absolutely fuck it up. I will fuck it up. I guarantee you, right? You will make the wrong call. So it's better just to not answer any question, even if you do know the answer, even if it's not incriminating, because you don't want to get into the habit of complying. You know, you don't want to get into the habit. So it's better to answer every question if you're going to go down this road. It's better to answer every question with some version of, I don't answer questions. I prefer to remain silent. I don't want to answer that. I prefer to be on my way, or so forth and so on. I decline to answer. I find I decline to answer to be a little bit sharp. The phrasing I've chosen, at least in my view, is a little bit softer. So I'd recommend slightly softer wording. And so that's how I'd recommend doing it. I decline to answer is a little sharp for my taste. And also, once again, or if you're going to say I decline to answer, preface it by sir or ma'am. Again, sir or ma'am gets you a long way. Sir, saying I decline to answer versus sir, I decline to answer is a very different tone. So first of all, I'd recommend softening it a little. Second of all, if you're going to go that route, sir or ma'am goes a long way, or officer, or sheriff, or other title as might be appropriate if you happen to know. So that's what I have to say about that. Yeah. Yeah. No, I'm not interested in playing your games is not the right phrase. Try again. That is an example of what not to say. That is a wrong answer. The House is planning to vote to throw McCarthy out. It's a stupid vote. They have no one to replace him. There's no one who has the votes to become speaker other than McCarthy. It's a completely stupid vote. Unless you get enough Republicans pissed to appoint a Democrat as speaker, which would just be the ultimate fuck you to the whole thing. That's the only other way this resolves. There's no one else on the Republican side with the votes to be speaker. Jordan doesn't want it. Scalise doesn't want it. No one else has the votes. No one else has close to the votes to be speaker on the Republican side except McCarthy. There's no one waiting in the wings. So it's a stupid vote because no one else other than McCarthy can be speaker on the Republican side. The only person that could possibly be speaker other than McCarthy is a Democrat. Because remember, there's only a 4-vote margin by the Republicans in the House. So all you need is five Republicans to say fuck this we're voting for the Democrat, and suddenly you have a Democrat Speaker of the House with a Republican majority. And you could definitely piss off the probabilities are significantly higher. They are much, much higher, by orders of magnitude higher. The odds of any random Republican becoming House Speaker are much, much, much lower than, say, Jim Jeffries, Democrat, becoming Speaker. Because 5 Republicans could definitely become pissed off enough to be like, fuck you, to Gates, and vote for the Democrat just to end this nightmare. And suddenly there's a Democrat Speaker in a Republican majority. That is a significantly more likely outcome. So the vote is stupid. It's stupid. There's no one else to do. It doesn't make any sense. It's a completely stupid vote. So the vote will fail to remove Jeffries. The vote will fail to remove McCarthy for the simple reason that there's no one else waiting in the wings. Unless five Republicans get together and call Gates's bluff and be like, okay, if you do this, we're voting for the Democrat, fuck you, which would be hilarious. I could see myself doing that as a Republican member of the House because I'm a contrarian. I could see that as I could definitely see myself as being the guy who I don't really like being strong-armed. Fuck you. I'm voting for the Democrat just to piss you off. I could totally see myself doing that as a Republican member of the House. I'm not sure how much longer I'm going to be a Republican member of the House in this scenario, but I could definitely see it happening. I could definitely see it being I don't like having my arm twisted. I don't like having this, this fight, constantly where you think you're the big dog in town. I don't like this power play. I don't like having my arm twisted. Fuck you. I'm voting for the Democrat. Just to fuck you. I could definitely see myself being that guy. So if you get 5 guys like me in the House, you're done. You're done. Yeah. This is a stupid game with stupid prizes, and I don't like it very much. All right, I'm going to sign off for now, guys. I think this stream, I'll make it members only because it's kind of a disaster stream. We don't need this as part of the algorithm, so I'll make the stream members only. So it'll be one that will only be available for the members. And I think we'll call it a day. I'm going to have some chili now. All right, guys. I've been Uncivil Law. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.